A New York Times reporter, Judy Miller, recently spent 85 days in jail defending a promise she made to protect the anonymity of a source. Some people thought she was heroic. Others said it was reprehensible that a journalist would refuse to testify before a grand jury. Still others said her source had released her from her promise a year ago and blamed her for being overly stubborn. How should society balance the need to prosecute lawbreakers with the need of journalists to protect their sources? I'm Sarah Bartlett, and this is our topic today on USA Inc. Joining us today is Steve Shepard, the Dean of CUNY's new Graduate School of Journalism, the former editor-in-chief of Businessweek magazine, and in the spirit of full disclosure, my former boss. Steve, thank you for being on the show today.
My pleasure, Sarah.
Wanted to talk to you about confidential sources. There's been a lot of press coverage of the Judy Miller case and her incarceration, and of course most recently her release. Why should the public care about all of this? Is this just something that's of interest to you and me and a few others, or?
Well, I'm afraid that might be the case, but the public should care, and they should care because the press is very, very important in informing the public. So it's a vital matter, and confidential sources, when used appropriately, provide a lot of very important information and bring to the surface things that would otherwise not come to the surface. So the public has a vital interest in this, and they should care.
Now, the two companies that had reporters that were at issue here, Time Inc. and the New York Times, they took very different paths in handling the case. Can you give us a little bit of background on what the issues were and why you think they responded so differently?
Yeah, the question was whether reporters should agree to testify because they get a subpoena from the federal prosecutor, Patrick Fitzgerald. In Time Inc.'s case, it wasn't just the reporter, but the corporation, Time Inc., was also vulnerable because they had notes and information that Matt Cooper had prepared. The New York Times was not a target itself, only Judy Miller. So they only had to be concerned with Judy's response and back her, but they were not at risk themselves. So there was a basic difference.
And let's just remind everyone what the subject of the articles were.
This is the question of whether a CIA agent, covert agent, was outed by a government official, or anybody for that matter, via a leak to the press. And there were several reporters who were subpoenaed, a couple from the Washington Post, Tim Russert from Meet the Press, Matt Cooper from Time Magazine, Judy Miller from the New York Times. And they all eventually gave testimony, some of them right away by negotiating an arrangement with the prosecutor, and some only by being compelled, like Matt Cooper, and finally Judy Miller, who went to jail but ultimately did testify.
Now, Time Inc., as you said, they were targeted as a corporation, and I think Norman Pearlstein indicated that that was something that influenced his decision to turn over Matt Cooper's notes. But the other issue that he raised at the time that he agreed was, he said, I've wrestled with my conscience, I've thought about this deeply, and I don't think that reporters can be above the law. The implication being that the Times thought its reporters were above the law if they didn't adhere to the same position. What do you think about the way he has constructed his response?
Well, it sounds very good, and generally speaking, it is true that publications and individuals should not be above the law. You should obey the law. But, in American history, there is something else which is called civil disobedience, which is you're not above the law, but you accept the sanctions of the law. In other words, for reasons of conscience, you say, I'm willing to go to jail, or I'm willing to fight, and accept the consequences and the penalties for disobeying the law. That's, in American history, that is an acceptable way of behaving, and it's happened many, many times in our history.
So then it comes down to Time was faced with steep fines. It was as a corporate entity, and the New York Times wasn't.
Yeah, Time Inc. was in a much more difficult position than the New York Times was, absolutely.
Now, the New York Times in the mid-'70s, if you look back through history, they had a similar situation, and I think Arthur Sulzberger Jr., when asked about this, said, well, we paid the fines. We were willing to accept the financial penalty. You have to be willing to put money down in an important issue like this.
Yeah, that's the Myron Farber case you're talking
correct.
about, where a New York Times reporter went to jail for many days because he didn't want to testify, give up his notes in a murder case,
right.
really. That raises all kinds of questions about what the limits are on confidential sources, whether this is an absolute privilege that reporters should always honor, no matter what, or whether you say under certain circumstances, for example, in a murder case, if you have evidence about a murder case and somebody's on trial and their life is at stake and you were given information, do you have an obligation to turn over that information, even though you promised confidentiality to the source? And you have to balance. There's a trade-off here between the needs of the criminal justice system to prosecute murderers and the needs of the press to protect confidential sources. And so it's very hard to take an absolute position in every single case. And in this particular case, what strikes me is that Karl Rove was the confidential source, we now know, or at least one of them. And the question really is, if he was manipulating the press, does the press have an obligation to protect him or not? Suppose somebody was lying to you and you found out later. Do you have an obligation to keep the confidentiality, or do you say, well, he lied to me, so I'm going to disclose the source? That wasn't part of the deal. He wasn't supposed to lie to me. In this particular case, the argument is that the press missed the real story. In their eagerness to protect the confidential source, Karl Rove, they missed the bigger story that the administration was trying to discredit critics of the war, starting with Joe Wilson.
Do you think that's true? I mean, there's been an awful lot of press coverage about the administration doing just that.
Yeah, it's just that it came out later that Karl Rove, the president's chief political advisor, was the one leaking the name of a CIA agent to the media and trying to manipulate, trying to get everyone to see that critics of the war, like Joe Wilson, were wrong. That's a big story, and it didn't come out for quite a while in the eagerness to protect the confidentiality of Karl Rove.
Now, you've analyzed the chronology, I know, of this, and does it not even stem back further than Karl Rove when you look at the phone logs and everything?
Yeah, I mean, the question, we still don't know a lot of how all this happened. Karl Rove claims he heard it from a reporter. My scenario is that what happened was that we know that the day after Joe Wilson wrote the op-ed piece in the New York Times criticizing the Bush administration and saying there's no evidence that Iraq was trying to get nuclear weapons material from Africa. The very day after he wrote that piece, we know that President Bush left on a long-planned trip to Africa, and that there was a memo that Colin Powell had aboard Air Force One with the whole story, and Joe Wilson's wife worked for the CIA and so on. We know from phone logs that Ari Fleischer, the president's press secretary at the time, talked by telephone to Robert Novak, the syndicated columnist who broke the story. We don't know what was said, but one theory could be that Ari Fleischer was the one who told Bob Novak that Joe Wilson's wife worked for the CIA. So that when Novak called Karl Rove, he told him, well, I've heard this. So Karl Rove could honestly say, I heard it from a reporter. Then Karl Rove called him back and confirmed, and then he got the rest, the other confirmation from probably Scooter Libby, Vice President Cheney's chief of staff, and then wrote the column.
So further evidence that, I mean, if this is true, if your scenario pans out, then further evidence that this was quite a manipulative situation.
An administrative leak, and the question is whether that's a violation of the law, which is unclear. It is against the law to knowingly out a covert CIA agent. But there's a lot of ambiguity what knowingly means. That they use her name. There's a lot of uncertainty here whether this was in fact a violation of the law. But that's what Fitzgerald is going after.
In a recent forum that you led, Norm Pearlstein was on the stage and said that in retrospect, I think you asked him, is there anything that you would do differently? And his answer was, I'm not sure that Karl Rove deserved confidential treatment, source treatment. Can you explain what you think he meant by that, and what is the significance of that?
Yeah, well, he was in an awkward position because his reporter, Matt Cooper, had promised Karl Rove confidential status. So an editor cannot take back a promise given by a reporter to a source. Otherwise, you can get sued for breach of contract, in effect. So he was in a tough position. What he was saying on the panel at the Graduate Center was that if I had it to do over again, I would have had a lot more discussion about whether Karl Rove deserved the status of confidential source, meaning we protect him no matter what. Because, look, he's the president's spin doctor, and this goes on in Washington all the time. If you have a 5-minute conversation with somebody on the phone, are they confidential sources, or are they just people who are pushing the administration's point of view, which is their job? And he was saying, in effect, he shouldn't have been a confidential source. We promised him that, but we shouldn't have.
So that comes down to training reporters about when to be able to offer this promise and when not to. And I mean, do you think it'll change the way that newsrooms handle this situation?
Well, it already is. We in the media have been very promiscuous in our use of confidential sources. We grant it quite routinely. Somebody says, "Well, I want to go off the record," and you go off the record, and when often there's no need for it. So we're going to see less use of confidential sources in the press. We're going to see more monitoring by editors of reporters before they give confidential status to sources. But, it's really impossible to police all the time because you've been a reporter, you know what happens. You talking to somebody and you're finding out all kinds of good stuff. You're not going to say, well, wait a minute, I have to
call my editor.
Have to call my editor, and you whip out your cell phone and call your editor. Hello, I'm onto a big story. It just isn't going to happen that way. But what you want to do is make those situations very minimal. So it happens rarely, and reserved for true whistleblowers who are really uncovering wrongdoing.
So there needs to be a lot of training and sort of...
And policing.
And policing.
Yeah.
We'll be right back.
The Zicklin School of Business at Baruch College of the City University of New York is the largest and most diverse accredited business school in the United States, offering high-quality, full-time, and part-time degree programs at the undergraduate, master's, and PhD levels. For information about the Zicklin School of Business, please visit our website, zicklin.baruch.cuny.edu. That's zicklin.baruch.cuny.edu.
Welcome back. I'm speaking with Steve Shepard, the Dean of CUNY's new Graduate School of Journalism. A lot of Judy Miller's case revolved around the use of waivers by confidential sources. Can you tell us what you think happened with her decision to identify him and go into the grand jury on the basis of a waiver? What are the issues there for journalists?
Yeah. There were 6 or 7 reporters who accepted the waiver from Scooter Libby. The one who didn't was Judy Miller, and she was the only one who went to jail. So it raises the question of what was going on. Her position, as reported in the papers, is that I never got a specific waiver and to release me from my pledge of confidentiality to Scooter Libby. I got a general waiver, and I was worried that it was coerced. Libby's lawyer, Joseph Tate, says that's not the case at all. We offered you very, very specific waiver of this pledge a year ago. And we're stunned that you didn't take it and it came to you going to jail. Floyd Abrams, one of Judy Miller's lawyers, says that's not the case. It wasn't that specific. We didn't believe it. We didn't trust it and so on. I don't know what happened, but my sense of it is that what lawyers do is negotiate all the time, and this was a clear misunderstanding. If a lawyer on one side is saying, we said X, and the lawyer is saying, no, on the other side saying, no, you didn't say X, well, pick up the phone and talk to each other and work it out. And I come away with this terribly sad feeling. I can't prove this, but I just come away with this sad feeling that she didn't need to go to jail. And that these lawyers should have worked this out and could have been able to work it out. So we don't know everything that happened, and maybe what I've just said isn't right, and we'll find out more. But on the basis of what's been reported, it troubles me that she was unnecessarily in jail.
Is it possible that she was just trying to sort of stand by a principle and make a very public statement? Is that...
Well, she was standing by a principle as she saw it, no question about it. And that's fine, but I don't know anything about her motives, really, so it's hard to say. It just, when you look at it, you say, come on, these two sides should have been able to get together and work this out. All the other reporters didn't go to jail. They're not unprincipled people. Why is it that she went to jail? What were the lawyers doing? Why was there a misunderstanding? Why couldn't you fix the misunderstanding?
It does seem very peculiar.
Yeah.
Do you think that we'll get into the business of waivers becoming part of the normal give and take of journalism? And how does a reporter decide when to accept a waiver and when not? I mean, we're entering new territory here.
Yeah, we are. I mean, I think that's, just up to what the reporter agrees to with the source, and what the source says, look, if push comes to shove, you can reveal my identity if it means you're going to jail, or when the time comes, call me up and I'll tell you whether I can release you from the confidentiality pledge. There's going to be a lot of negotiation, a lot of back and forth, and the worst thing is there's going to be the chilling effect on sources being willing to talk to reporters on a confidential basis, because they think at some point they're going to get a phone call which says, I'm about to go to jail, would you release me from my pledge? And they don't want to release it from that. The whole point of the confidentiality was to be confidential. So we're in for some difficult maneuvering here.
I don't know if you ever watched The West Wing, but it's even entered the fictional world of politics and journalism.
Yeah.
They have a session right now on exactly this case. I think for journalists, this is, like you said, if you're sitting in an interview and somebody's telling you stuff that you think is really important, it's very hard to imagine someone saying, well, let's stop now and negotiate the terms of this conversation going forward. I mean, that alone would have a chilling effect.
Yeah.
So do you sense already that we're not breaking the kinds of stories that we used to, or that you can actually start to feel that we're in a more fearful environment?
I can't prove that, and various editors claim it isn't the case, and we're still doing as many investigative stories as before, but it's hard to come up with real evidence to quantify the effect. I can't believe there isn't some pulling back by sources. I mean, it just would go against human nature. It's one thing to talk, without fear, and another thing to talk knowing that you're in for a negotiation.
Do you think that the journalism has come in for great criticism over the last few years in particular. Do you think that some of this, seeing a reporter go to jail, seeing them trying to stand up for principles, is actually going to perhaps help improve the image of journalists?
I don't think so. I was quite stunned by the lack of public outrage that a reporter went to jail. And I don't know why that was. People just don't care about reporters or the media, whether it was the particularities of this case. This wasn't a really good, from the press's point of view, not a really good confidential source case. You would want a whistleblower who was uncovering all kinds of wrongdoing that clearly was in the public interest, for the public to rally around and say, this is important. We're not going to get this information without the media having confidential sources. And that wasn't the case here. It was just Karl Rove,
in some ways it was even worse, was it not? Because for many people, watching a New York Times reporter go to jail to protect the White House administration spin doctor made it look, I think, even more that there was sort of a cahoot. I mean, if you were conspiratorial, you would say, big media is in cahoots with the administration.
Right. It appeals to both the left wing and the right wing. The left wing can say, to hell with the Bush administration if Karl Rove goes to jail, good. And the right wing can say, to hell with the New York Times.
Yes.
If the reporter goes to jail, the hell with her,
Which leaves us with bloggers. What do you think about what all of the impact of this is going to be on the world of the blogging media?
Yeah. See, the whole discussion now about a shield law is totally changed from what it would have been 3 or 4 or 5 years ago.
Why don't you stop and tell everyone what a shield law means?
49 states have some version of a law that says the reporters have a privilege to protect confidential sources, just as a religious figure, minister, has a privilege not to disclose what is told to him by a congregant, and just as a lawyer has a privilege not to tell what a client tells him, and just as a spouse has a privilege not to be compelled to testify about what his or her spouse says in the marital relationship. And journalists, have a similar privilege not to be forced to disclose, okay? The problem in the Judy Miller case was that there is no federal shield law. There are state laws, and this was federal law that was taking place, so there was no protection. There's now a movement in Congress to pass a federal shield law. One of the problems is about the bloggers. How do you define who a journalist is? And so if anybody can go online and write a story or comment on the news, well, he should be protected. I mean, who's to say who's a journalist? We don't license journalists in this country. And in the early history of this country, we had pamphleteers, Tom Paine and so on. who are the bloggers of their day in a way. So what do you do about the bloggers? There's no good answer to that question.
But if you're a blogger and someone tells you something that's very critical and asks for confidentiality and you give that promise, you're essentially saying they have no protection whatsoever.
Well,
in a federal case.
In a federal case, even reporters for the New York Times have no protection. So it's not just bloggers. But if you had a shield law, how do you define who a journalist is? So if a blogger prints something based on a confidential source, should he or she be protected by the federal shield law when it gets passed, if it gets passed?
So we have to define a standard for when does a blogger become a journalist?
Yeah, I think it's very, very hard to do. I mean, you write one book, are you a journalist? You write one great story, why aren't you a journalist?
It's a hard question to answer. In terms of the federal shield law, I mean, I think there are some people who would say that is becoming an absolute privilege to a journalist. What if you have a situation, you know, like you described a murder? Is it right for journalists? I mean, is that a fair balance for our society to say we grant you this privilege, you can protect the identity of someone in a situation that's very serious where a crime has been committed?
I think that it can't be absolute. You know, the privilege can't be absolute. There have to be cases in which it is in the public interest, on balance, for a journalist to testify in a case, or where they've been lied to or manipulated in some way. So there are certain purists, First Amendment purists, who say it should be absolute, but I think in the real world, if we get a shield law, and I hope we do, that there'll be some language written in that under certain circumstances, trade-offs have to be made, and the person weighing whether those trade-offs are made will be a federal judge.
Do you think, from what you know, that we'll get a federal shield law anytime soon? Any prognosis?
I don't really know. It's very interesting who's in favor of shield law. You know, Bob Dole has been very outspoken. I mean, he's not in the Senate anymore, but he's been very outspoken about the need for a federal shield law. And there are plenty of Republicans and libertarians who think there ought to be. So it is possible we'll get one. You know, 49 states have one, so it isn't...
At the state level?
At the state level.
Well, who's opposing it?
People who, a certain number of intellectuals who don't believe the press should have a privilege. And there are some who just argue intellectually that they shouldn't have a privilege. And then people who don't like the media are against it. And then people who just say, look, it's impossible to write one because we don't know who a journalist is, and it's going to be worse if we start trying to define who a journalist is. You know, the press is free and we don't set standards, we don't define who the press is. Anybody's free to write what they want.
One of the things that surprised me about the Katrina coverage was the extent to which the role of journalists and their position seemed to be redefined once again. They were credited with telling a story that wasn't available anywhere else, and in some ways it validated the role of journalists. Did that surprise you? Did you have the same sense that there was outrage and finally journalists were on the right side of the debate?
Well, it didn't surprise me because I think there's a lot of very good journalism that's being done in this country, and it's getting lost in the whole argument about the media, you know, liberal, conservative, and so on, and the rise of bloggers and new technology. But during Katrina, the media, television and print, did a wonderful job of coverage. And I think it reminded people that, by God, we have a free press for a reason, and they often do a very good job. Sure, they make mistakes, and sure, there are scandals once in a while. Name me a profession that doesn't have mistakes and scandals from time to time. But that the media really can do a very, very good job. And they did in Katrina, a wonderful job.
Yeah, it was really exceptional. We've been fortunate to have the Dean of CUNY's new Graduate School of Journalism, Steve Shepard, as our guest today. Thanks, Steve, for being on the show.
My pleasure. Thanks.
We'll be right back.
Some people think of New York as the world's second home. The City University of New York, with students coming from 90 countries and speaking more than 155 languages, is the world's first university. Find us on the web at cuny.edu or call us at 1-800-CUNY-YES.
While many states in this country have shield laws on their books that allow reporters to protect the identities of their confidential sources, This protection varies from state to state and provides no protection at all in federal court. The Judy Miller case makes it clear that a federal shield law is necessary, especially with mounting pressure on journalists from both an aggressive White House and a skeptical public. 22 reporters received federal subpoenas last year, compared with fewer than 9 a year on average from 1991 to 2001. Bipartisan legislation has been introduced in both the House and the Senate to establish a federal shield law. It addresses potential critics head-on by carving out an exception that if a reporter has exclusive information that is essential to solving a crime or for national security, that reporter would be compelled by law to disclose that information, though not a source's identity. Sadly, this legislation is languishing in committees. For a democracy to thrive, journalists must thrive too, and for journalists to thrive, they must be able to protect their sources. For USA Inc., I'm Sarah Bartlett.